He was on his way home from the night shift. It was just past 1 in the morning. He had two young daughters asleep in the back seat. He had a routine, the same highway, the same exit, the same prayer he said in the car every evening that he still made it back in one piece. He was not drinking, he was not speeding, he was not on his phone. He had a registered handgun in the center console, locked in a quick access holster, with a valid concealed carry permit in his wallet. He was, by every reasonable definition, a careful man. A patrol car came up behind him with its lights on. He pulled over. He signaled. He turned off the engine. He rolled down the window. He placed both hands on the steering wheel where the officer could see them. The officer walked up to the window. The officer's flashlight came on, but it was not pointed at him. It was pointed at the car. The officer's first words were not license and registration. The officer's first words were a question he had heard on TV 100 times, but had never been asked in real life. "Sir, do you have any weapons in the vehicle?" He paused. He thought about the permit. He thought about the fact that he had done everything right. He thought about how a polite, honest answer would probably make this easier. So he answered honestly. He said yes. What happened next did not feel like a traffic stop anymore. The officer stepped back. He reached for his shoulder radio. He keyed it up. Within 2 minutes, two more patrol cars were on the scene. Within 4 minutes, an officer had a flashlight aimed at the rear of the car where his daughters were sleeping. Within 6 minutes, the officer asked him to step out of the vehicle. Within 8 minutes, the officer asked for proof of the permit. Within 10 minutes, a fourth officer had arrived with what he recognized by the smell of it as a drug detection dog. 28 minutes passed. He had done nothing wrong. He was not arrested that night. He was issued a written warning for the original traffic violation. He took his daughters home. He put them in their beds. He kissed his wife on the forehead. But what he said during those 28 minutes was typed into a police report. And that report did not stay in that county. That report was entered into a state database. That report was flagged. And 4 months later, he was pulled over again on a different highway in a different town by a different officer. And that report, the words he gave voluntarily in the dark with his daughters in the back seat, followed him out of the car and into the courtroom. He had done one thing wrong. He opened his mouth when he did not have to. He thought honesty would protect him. What he did not know was that in 2015, the United States Supreme Court had made a unanimous decision, a 9-0 ruling that, if he had only known it, would have changed every word he said that night. That ruling was Rodriguez versus United States 575 U.S. 348. Decided on April 21, 2015. The docket number was 13-9972. Justice Ruth Bader Ginsburg wrote the opinion. The vote was 9-0. It was unanimous. Every justice on the court agreed on the rule. The court said the quiet part out loud. The court said that during a traffic stop, the police cannot keep you there just to fish. They cannot turn a routine stop into a criminal investigation without a real, specific reason that was not there before they pulled you over. They cannot delay your release just so a dog can show up. That is the rule of the land right now, and every officer in every state is supposed to follow it. Now, this is going to sound strange to hear from a YouTube channel, but listen to me. Subscribe to this channel before you need this information. That is not a generic ask. If this channel is on your side before something goes wrong, you are already ahead of the people who never heard any of this. Hit the bell, hit subscribe, hit the notification, so that the next time a 9-0 ruling comes down, or the next time a question is asked at a traffic stop that could put you at risk, this information comes back to you the day you need it, not the year after. And if you think of one person in your life, your brother, your cousin, your coworker, your neighbor, your daughter's boyfriend, who drives a lot, who carries for protection, who has kids in the car, who has been pulled over before and never quite knew what to say, send this to them before they need it. That is not a favor. That is preparation, because the next time the lights come on behind them, they will either speak from confidence or they will speak from panic. This video is what confidence sounds like. Now let me get into the law that surrounds the question, do you have weapons? Because that question is not small talk. That is the first test of whether you understand the rules or whether you are about to lose them. There are two amendments doing the heavy lifting here: the Fourth Amendment and the Fifth Amendment. Both of them protect you during a traffic stop, but they protect you in different ways, and most people only know about one. The Fourth Amendment to the Constitution is the one that says you have the right to be secure against unreasonable searches and seizures. What that means in plain English is that the government cannot stop you, detain you, or search you without a good legal reason. We call that good legal reason probable cause. Probable cause is just a legal reason to search. It is not a feeling. It is not a hunch. It is not what an officer suspects based on the way you look or the neighborhood you came from. It is an actual, specific, articulable reason that would make a reasonable person believe a crime had been committed or that evidence would be found inside your car. The Fifth Amendment says something different. The Fifth Amendment says you have the right to remain silent. It says you cannot be compelled to be a witness against yourself. That means you do not have to answer questions that could later be used against you. It does not depend on whether you are guilty. It does not depend on whether you have something to hide. It is a right. It is yours, regardless. These two amendments work together. The Fourth Amendment protects your space. The Fifth Amendment protects what comes out of your mouth. Officers are trained on both of them, which means when an officer walks up to your window and asks, "Do you have any weapons in the vehicle?" That is not a routine question. That is an entry point. Here is the case that changed how stops are supposed to work. In 2015, the Supreme Court decided Rodriguez versus United States. The vote was 9-0, unanimous. Every justice on the court signed on to one opinion. The docket number was 13-9972. Justice Ginsburg wrote it. The case came out of Nebraska. A driver was pulled over for what started as a routine traffic violation, drifting on the shoulder, the kind of stop that should have ended in 2 minutes and a written warning. The officer issued the warning. So far, the stop should have been over, but the officer did not let the driver leave. The officer kept the driver there. The officer called for a K-9 unit. The dog arrived. The officer walked the dog around the vehicle. The dog alerted. The officer searched the car and found a controlled substance. The driver was charged. The question that went all the way to the Supreme Court was simple. Can an officer, after finishing the reason for the stop, keep you there just to wait for a dog? The Supreme Court said no, unanimously. Justice Ginsburg wrote that extending a stop, even by a few minutes, beyond the time reasonably required to address the traffic violation, violates the Fourth Amendment. The court said it clearly. The court said that in the absence of reasonable suspicion of some other crime, an officer cannot keep you there. This is what legal scholars call a bright line rule. It is not a suggestion. It is not a guideline. It is the rule of the land. Every officer in every jurisdiction is supposed to follow it. The reason the vote was 9-0 is that the court did not think this was a close question at all. They thought it was obvious. You cannot detain a citizen beyond the scope of the original stop without a real new reason. And here is where it gets important, and here is where most people lose this protection. The Rodriguez ruling protects your time. That is what it does. It puts a clock on your stop. It says an officer cannot keep you past the time the original reason for the stop actually takes. But the Rodriguez ruling does not protect what you say during that clock. It does not protect you from your own mouth. The Rodriguez decision does not give you a magic shield over your words. It gives you a time limit. The clock is real. But if you throw the clock away by talking when you do not have to, the case will not save you. That is the trap. On one side of this fight, you have your constitutional right to be free from unreasonable detention. On the other side, you have your own willingness to keep answering questions politely, honestly, sometimes nervously, that are slowly turning a warning into an investigation. You are protected on one side of this fight. You are completely open on the other side. Now let me show you how this trapdoor actually opens. And I need you to pay close attention here, because this is where the loss happens for thousands of Americans every single week. Let me walk you through a documented pattern. It has played out across the country. I am not going to give you a name because I do not have consent to identify a private individual in a legal situation. But I will walk you through the structure of what happens. A driver is pulled over in Texas. He has a valid concealed carry permit. He has a handgun in the center console. The officer walks up to the window. The officer asks for license and registration. The officer then asks, "Sir, do you have any weapons in the vehicle?" The driver, who has done everything right, who has followed the law, who has nothing to be ashamed of, answers, "Yes, sir, I have a permit. It's in the console." The officer steps back. The officer calls for backup. Within minutes, 2 more units arrive. The driver is asked to step out. The driver is asked for the permit in writing. The officer runs the permit through a database. The officer then begins to ask more questions. "Sir, do you smoke marijuana? Sir, have you been drinking tonight? Sir, where are you coming from? Sir, who was with you yesterday? Sir, do you mind if I take a quick look in the trunk?" Each question feels small. Each question feels like a casual conversation. Nobody is arresting him. Nobody is pointing a weapon at him. There are no handcuffs. The officer is, in fact, polite, and that is part of the problem. The politeness tells the driver that he is being treated fairly. The politeness makes him want to be polite back. But every answer he gives is being entered into a police database, cross-referenced, stored. And over the next 4 weeks, those answers are cited by officers in 2 different states as part of the reasons they had for pulling him over again. The answers he gave voluntarily that night became probable cause in the next stop. They became justification in a future search. They became a reason a prosecutor's office could file charges that they could not file on their own. The trapdoor was not a single mistake. The trapdoor was a pattern. He kept answering, he kept volunteering, he trusted the officer because the officer was professional. He thought the officer was on his side. And in a narrow sense, the officer was. But the officer's job is not to be on his side. The officer's job is to find a reason to keep investigating. That is the trapdoor, and that is where most people lose. Now let me show you the part that the court did not write down but is just as real. The Fourth Amendment protects you from being detained without a reason. The Fifth Amendment protects you from being forced to testify against yourself. But neither of these amendments protects you from volunteering. That is what they did not tell you. The protection from Rodriguez versus United States, the unanimous 9-0 protection, is real. But the moment you start answering questions, you are giving up that protection 1 word at a time. Even worse, in federal jurisdiction, lying to a federal officer is a felony. The relevant statute is 18 U.S.C. Section 1001. It carries up to 5 years in prison. Many states have similar laws on the books with similar penalties. If you say, "No, I do not have any weapons," and the officer later finds one, you may be charged separately with a false statement. If you say, "Yes, I do," the officer now has reason to escalate the encounter, request backup, run a search, and continue the investigation. Either answer can hurt you. The first answer, the honest yes, produces a chain reaction. The no produces an additional charge. And the third option, silence, is the only one that cannot be cited against you later. That is the trapdoor. Most drivers think there are 2 choices, lie or tell the truth. They do not see the third door. The third door is the door labeled, "Officer, I am choosing to remain silent. I am not consenting to any search of this vehicle. Am I free to go?" That third door is the door you actually want. The protection of the Fourth Amendment, the unanimous 9-0 protection of Rodriguez versus United States, the protection of the clock, that is all real. The moment you start opening your mouth for anything beyond basic identification, you are throwing the clock away. And the officer does not have to tell you that you are throwing it away. The officer's job is to keep you talking until they find something else to charge. This is not cynicism. This is the structure. This is the documented pattern of how traffic stops escalate. And the unanimous 9-0 vote in Rodriguez versus United States was the Supreme Court telling every officer in the country, we, the court, will not let you invent a reason to keep someone. But the court also acknowledged in that case that we cannot stop a citizen from giving you the reason themselves. That is exactly the trapdoor you just saw open right in front of your eyes. And there are only two ways to handle it. Either you walk through the door the officer puts in front of you, or you stand still and ask whether you are free to go. Let me now give you the survival protocol. This is what to do, not in theory, in real life, what to say, what not to say, and when to say it. This protocol is built for the moment the lights come on behind you. Practice it before you ever need it. Number 1, the moment you see the lights behind you, slow down, signal, pull over to a safe place, turn off the engine, roll down your window, put your hands on the steering wheel where the officer can see them. Make sure the officer feels safe. That matters more than people realize. The officer's perception of safety influences how the stop unfolds. Number 2, when the officer walks up, he will ask for license, registration, and proof of insurance. That is required. You provide those documents, but do not reach for them until the officer asks. Once he asks, reach for them slowly. Announce what you are reaching for. Sir, my registration is in the glove compartment. I am reaching for it now. That one sentence can prevent an escalation that you do not want any part of. Number 3, after you hand over the documents, the officer will often ask a follow-up question beyond identification. Maybe it is, do you have any weapons in the vehicle? Maybe it is, where are you headed? Maybe it is, have you been drinking tonight? Maybe it is, do you mind if I take a quick look in the car? Whatever the question, the moment it goes beyond license and registration, the protocol begins. Then you say this, word for word. Officer, I am choosing to remain silent. I am not consenting to a search of this vehicle. Am I free to go? 3 sentences, that's it. If the officer says yes, you drive away. If the officer says no, you stay silent and wait. Do not continue to explain. Do not apologize. Do not justify. Stay silent. Let the officer finish whatever he has lawful authority to do. If the officer asks a second question, you repeat the same 3 sentences, exact same words, same tone, polite but firm. You do not have to be rude, but the words do not change. Repetition is the point. Repetition is what your attorney would want you to do. Number 4, if the officer asks for consent to search the vehicle, and he will use phrases like, would you mind, would it be okay if, do you have anything in there I should know about? You answer no, out loud, specifically. The exact words are, officer, I do not consent to a search of this vehicle. Do not let the officer rephrase it as a courtesy. Do not let the officer turn the request into a small thing. It is not a small thing. It is the foundation of every search that follows. You say no, politely. Then you wait. If the officer proceeds to search without consent, you do not physically resist. You say out loud that you do not consent. You let the officer do what the officer is going to do. Your job in that moment is to preserve the record. Physical resistance can hurt you. Verbal refusal preserves your rights. Number 5. The next move is the most important part of the entire protocol. Do not move your hands suddenly. Do not reach for any object. Do not swing open the glove compartment. Do not volunteer to take out the weapon. If you have a firearm in the vehicle, you keep your hands visible at all times. You wait for the officer's instruction. You follow the officer's instruction exactly. If the officer tells you to step out, you step out. If the officer tells you to keep your hands where he can see them, you keep them there. Voluntary compliance is not the same thing as voluntary conversation. One protects you, the other does not. And finally, the single line that saves you more than any other line. The single sentence I want you to commit to memory from this entire video so that you could say it tomorrow morning, by heart, under pressure, in the dark, with your hands on a steering wheel? Is this, "Officer, I am choosing to remain silent. I am not consenting to any search. Am I free to go?" That sentence, repeated calmly and at the right moment, beats 90% of what the average driver does. It gives the officer the law. It gives you the protection. It does not give up anything that can be charged against you later. Save it. Write it down. Say it out loud in your car at least once before you ever need to say it for real. Because if you have never said it out loud, you will not say it that night. Now, let me close this out and put it back together. The Supreme Court has already ruled. Rodriguez versus United States, decided April 21st, 2015, docket number 13-9972. The vote was 9-0, unanimous. Justice Ginsburg wrote the opinion. The court said that during a traffic stop, you cannot be detained indefinitely without a real new reason. That ruling is still on the books. It has not been overturned. Every officer in every state is supposed to follow it. But that ruling protects your time. It does not protect your words. Your words are protected by the Fifth Amendment. And the Fifth Amendment only works if you actually use it. The moment you start answering questions that go beyond identification, you begin opening doors. You begin giving the officer reasons to keep going. You begin turning a stop into an investigation. That is the trap door. The protection is real. The moment you do what most drivers do, it is gone. That is the mistake. That is where most people lose it. The single step that saves the most is this. Officer, I am choosing to remain silent. I am not consenting to any search. Am I free to go? Memorize it. Say it out loud. Say it before you need it. This is not about being uncooperative. It is not about hiding something. It is about being prepared, knowing what your rights are, knowing what they cost. The cost is one short sentence. The benefit is everything else. Let me leave you with this. Listen to me carefully. The next time the lights come on behind you, you will have a decision to make inside the first 60 seconds of that stop. You will either answer questions you did not have to answer, or you will say the 3 sentences that protect you. There is no middle. There is no compromise that helps you. There is only the prepared driver and the unprepared driver. You are now the prepared driver. Walk in with the protocol. Drive with it. Keep it in the car with you. Tell the people you care about. Send this to them before they need it, because the information in this video is not entertainment. It is the difference between walking away from a stop in 2 minutes and walking into a courtroom 3 months later.